Legal terms. Part 5. Taxation. Levying of taxes is known as taxation. A tax is a compulsory exaction of money by public authority for public purposes enforceable by law, and is not payment for services rendered or to be rendered. A tax is collected for public purposes. A fee is supported by consideration, whereas a tax is not. A fee may be collected even by individuals, whereas a tax may be collected only by a government. Tenant. It is a designation given to a person occupying lands or building belonging to another on an agreement to pay rent for occupying that land or building. He is a party to an agreement of tenancy, the other party being the landlord. His rights and obligations are laid down in the agreement of tenancy in case where he is a contractual tenant, and in case of a statutory tenant, his rights and obligations are provided in the relevant act or acts of legislature. Title. Title is a right to a property, office, or an appointment. It is transferable either by sale, or by settlement, or by gift, or by will. Such a transfer is for consideration in some cases, and for no consideration in other cases. Such a title is created by a document, transferred by a deed, devolving upon succession, or inherited by inheritance. Titles are jurisprudentially acts or events that create, transfer, or destroy rights. Tort. Tort is an act or omission which is unauthorized by law. It is a kind of a civil wrong. Therefore, the affected person can claim unliquidated damages. A tort is often distinguished from a crime. A tort is a wrong done to an individual, for which the wrongdoer is liable to pay damages. A crime is a wrong done to the public as a whole, for which the offender, wrongdoer, is punished by the state. Tort is different from breach of contract, breach of trust, and breach of other equitable obligation. Trademark. A mark used for denoting that the products are the manufacture, or the goods are the merchandise, of a particular person, is called a trademark. The use of certain trademarks is necessitated to distinguish the goods of the proprietor of a particular trademark from similar goods in the market. Transfer. A permanent alienation is a transfer. Such an alienation may be in respect of movables or immovables. All the rights hitherto enjoyed by the owner are transferred to the buyer, or other alliance. It is not necessary that every transfer must be supported by consideration. A transfer may be absolute or conditional. Treason. It is an offense against the state. It is the highest known crime. It aims at the very root of government itself. In India, treason is applied to the waging of war, and attempting to, or abetting the waging of the war against the state, and is punishable under the Indian Penal Code. Trespass. A trespass is an injury committed with violence, and this violence may be either actual or implied. Though violence is not actually used, law will imply violence, where the injury is of a direct and immediate kind. An assault is an actual violence. Peaceful but wrongful entry into other man's lands is an implied violence. Trial. The examination of a cause for a case, civil or criminal, by a competent court is known as trial. Trial ends in a conclusion, by a competent court, of questions and issue in its proceedings, whether civil or criminal. The hearing of a cause of action, civil or criminal, before a judge who has jurisdiction over the matter according to the laws of the land, is also known as trial. Trust. A trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him, for the benefit of another, or of another and the owner. The person who creates a trust is called author of trust, and the person or persons in whom the trust is created are called trustee or trustees, and the person or persons is whose favor a trust is created is or are called beneficiary or beneficiaries. Sometimes a trust is created for the benefit of the owner himself. Ultra vires. Ultra means beyond, and vires means powers. If certain powers are legally conferred upon a person, that person can exercise only those powers. If he does not act beyond the scope of those powers, he is said to have done the act, ultra vires. This term is very popularly used in constitutional matters, and also in company matters. We know that when the Parliament or an assembly passes a law, the passing of that law being beyond the powers of the Parliament or the Assembly, the Supreme Court or the High Court declares it unconstitutional as being ultra vires the Constitution. Usage. The term means what the people are now or recently in the habit of doing an act in a particular place. It may be that the particular habit is only of a recent origin, or it may be one which has existed for a long time. A habit may be called usage only in reference to a particular place. A usage in the long run may become a custom, provided it is very ancient, continuous, accepted by the majority of the people. Verdict. The finding of a judge made by way of declaration is called verdict of the court. A verdict may be either general or special. A general verdict is orally delivered in court. Special verdict is popular in English law only. If an accused is adjudged as guilty, guilty as charged, or not guilty, this is a general verdict. Special verdicts are not allowed under the Pakistan Penal Code. Vis-Major. This term means or indicates act of God. Any act which is beyond the control of human beings, or any event which is supervening and creating an impossibility in the efforts of a human being, is known as act of God, for which no one is responsible nor liable. Such act cannot be foreseen by human beings. It is beyond their ability, beyond their control, beyond their perception. If a party to a contract is unable to do his obligation because of a supervening impossibility due to an act of God, he is excused for non-performance of that obligation. Void. It means nugatory, ineffectual, or inoperative. This term is used when total lack of existence is intended to be conveyed. It is a vacuum. A vacuum creates nothing. Likewise, a thing which is void creates nothing enforceable by law. Sometimes, a thing which has been in existence may become void. In such a case, the court is required to declare the thing as null and void. But a thing which is void, which has never existed, need not be declared null and void by the court. 101. Voidable. A thing which can be avoided is a voidable thing. A thing which has been valid in the beginning may become void subsequently. But a thing which is voidable in the beginning continues to be voidable until it is avoided. Such a thing is valid until avoided. It is in between these two. A thing which is avoidable becomes valid if it is not avoided, and it becomes void if it is avoided. But a thing which is void can never become valid. Void and voidable are concepts developed in the primitive law of contract. Waiver. It means relinquishment of one's right. It is preferable to a conduct signifying intentional abandonment of a right. It may be expressed or may be even implied. Waiver is a voluntary abandonment of a known existing legal right constituting a conduct warranting an inference of the abandonment of the right. Waiver, in such a case, is a defense against the subsequent enforcement of the said known right.